law matters can be both confusing and frightening. And with all these different questions, it's very difficult to find the source for answers. Well, here's one for you. You can ask Andrew. Ask Andrew is the only online-based call-in show where Andrew Feldstein of the Feldstein Family Law Group makes himself available to answer all of your family law questions. So tune in and ask Andrew.
Hello, and thank you for joining us today for the Ask Andrew Show, Canada's first Facebook Live streaming show. That's a Q&A show for family law. My name is Andrew Feldstein, and I'm the managing partner of Greater Toronto Area family law firm, Feldstein Family Law Group. Here, we practice exclusively family law, and we don't practice any other areas of law. This way, we can focus on solving your family law problems. Today, I'm answering your family law questions with my guest host, Samantha Collier. Please feel free to ask questions in the comments section. Sam, I'm going to hand it over to you and let you host the show now.
Perfect. Well, thanks for having me on the show. It's great to be back. Before we get started, there's this big news story going around that I'm sure everyone's hearing about, and it's about Kim Kardashian's brother, Rob Kardashian, and he was not married, engaged to a lady named China. They had a child. They recently broke up, and I think it was because he sent out very intimate pictures of them all over the internet, and they've been dubbing it revenge stuff. Now, a lot of people seem to be concerned about these pictures and if they have legal ramifications for sending these sorts of pictures. Like, could someone get a divorce based on someone sharing pictures like that on the internet?
Well, I'm going to start with, it's an interesting question that you have saying, can someone get a divorce on that basis? Here in Canada, there are 3 grounds for divorce. One is living separate and apart for a year. Yeah. And that could be living in the same home in separate bedrooms, not carrying on as husband and wife any longer. In my experience, that's the one that's always relied upon because you wait your year and you get your divorce if you've settled everything else. The question I'd have in my mind is, would that form cruelty? I can tell you I've never seen any cases where that does form cruelty, but it might be a novel argument to try. There might be a cause of action for that, but you also have to think about the optics that it creates in a family law dispute. You're walking in front of a judge. You're asking a judge to make findings. So let's say you're suggesting there ought to be joint custody, and you circulated these compromising photos of your former spouse. Your former spouse is going to say, how can I ever work cooperatively with that person when they've done that? Yeah. I should have sole custody because this is really problematic for me. One day I'm going to have my kids, our kids, asking me questions about this.
Yeah.
And one day the kids are going to know that dad is the one that circulated these photos. So people don't necessarily think of the fallout because even if you get into there's damages arising from that, money can come and go. But how is your 8-year-old child going to feel when they're now 12 or 13 years old and they're sitting there at school with their friends in the computer lab and they're doing a search on their mom and dad's names and up comes all of these pictures or videos of mom? Can you imagine the level of embarrassment for that child? And then the child... And then I know that my kids tell me all the time, sometimes they're in the lab at school and they'll do a search on me or go on my website. And that makes me think every time I do these shows or I do an appearance somewhere, my children may watch one day.
Yes.
So I have to be careful what I say in that regard. And here, just imagine that child then comes home and says, Mom, what happened? Why did you do these things? I'm upset with you. That was so embarrassing. And the mother says, well, Dad posted them.
Yeah.
You know, that's just, it's a horrible place they're putting those children in. And so you may want to do that. There's a real urge to doing that, but you got to refrain from doing them. I'll never forget, I had one of my clients once put up a website, and it had a imitation of the wife on the website talking and put her voicemail messages on. And
what?
Yeah. And on one hand, that may be the reaction you might get watching it. But on the other hand, I'm picturing myself having to defend that in court.
Oh, yeah.
Now, fortunately, we found out about it within the first day that this was live. We contacted the client and said, you got to take this down. This cannot be up. This is not helpful. And the client took it down and we never had any fallout over it. But there's desire for people to do this. And there's real cases where people have made comments on Facebook that are really negative about the other parent when the child is one of their Facebook friends.
And that happens. That happens. I mean, my daughter is on Facebook, and I'm very aware of what I post. And I think when people get divorced or broken up, the amount of feelings for revenge are so high that the people really need to be aware that they shouldn't be posting, not just these revenge porn pictures, but just any sort of comments, to be very aware of what they're posting online.
Well, I think the problem stems from, when I think of growing up, we weren't walking around with our cell phones and constantly online. So if you had a breakup with somebody, you'd go to your friends, you'd go to your family. You might say to your friends and family, oh, I think this of my ex, I think that of my ex, and all the negative stuff that you need to get out in order to start to feel better, to vent. The problem is with the generation now that's so used to being online, they want to vent the same way our generation may have vented. Even though I don't like to think of myself as old, but their venting is on Facebook. Their venting is on Instagram. And the difference is, I go talk to my brother and I'm venting. At the end of the conversation is over. There's no record of the conversation, versus Facebook or Instagram, even Snapchat. People will take a photo or take a screenshot of what's on Snapchat. So you really have to realize that when you put something on the web, you need to assume it will always be there. You should also assume, no matter what your privacy settings are, don't think you're perfect. Your privacy settings may be flawed, and that other person may actually see something you don't want them to see, or that one of your friends that you think is trustworthy isn't, because you may have 3,000 friends on Facebook. So really keep it to, if you're going to vent, do it by talking to people, not online. That's
the best advice that I've heard. I think that's great. So I'll move on to the next question that I have here. It was that we got this on Facebook, and it was about limitation periods in family law. Specifically, someone's ex-spouse ignored a court order and still asked for a trial several years later. Can you clarify limitation periods in the Family Law Act? For example, can someone try to claim property a decade after separation?
Okay. It's an interesting question, because for the particular person that asked it, I can't comment on what a court order says, but it tells me if a court order was made, there's probably a live court action. If there's a live court action, the limitation period deadline is in relation to when you started the court action. So for that question, most likely the court action has already started. Now, there are various limitations under the Family Law Act. The first one I'll talk about is for division of net family property. That one actually has 3 different limitation periods. The first one is 6 years after the date of separation. But if the parties get divorced, it can be reduced to 2 years after the date of divorce. If somebody dies, it's 6 months. Now, the last caveat there is discretion for a judge to extend it. And there's a lengthy test that you have to go through to extend it. So I'm going to start by saying the smart thing to do is to always get your claim advanced before the limitation period expires. And the other nuance to this issue is, in a lot of cases, we will have an argument about what is the date of separation, because that's the triggering event for your limitation period. So we're sitting here in 2017. One person may say, we separated in 2013. The other one may say, no, we separated January 2011. Because the one who says January 2011 wants to say, limitation period's expired, you don't have a claim. And then you have to ask the court for an extension. So that's one of the limitation periods. Now we get to where it even gets more confusing, because this applies usually for common law people, but it can also apply if you're married and you're trying to say, I have a beneficial interest in assets of my other spouse. So I'm going to start with, if it's a beneficial interest claim over personal property, and personal property means anything that isn't real estate, the limitation period is 2 years from the date of separation. So let's say you're common law and you want to say, I have a beneficial interest in all of the assets of the other side other than real estate. You have 2 years. That would include pensions, RSPs, stocks, bonds, maybe their business, because you were told you're going to be a shareholder. Now it gets more complicated, because There's another limitation period. If you're making a trust claim over real estate, the limitation period is 10 years.
Wow.
So that's where we even have married people will get into an argument saying that when the house is increasing in value after separation and they're not on title, they'll try to say, well, actually, you were holding half of it in trust for me, so I want to share in that increase after separation. Well, they have 10 years to make that claim.
Wow.
But the periods of time to make your claims on a trust interest cannot be extended. Those are hard and fast time periods. So it's really, in fact, a very difficult and challenging thing for people to follow. And when you come into Feldstein Family Law Group, we discuss those limitation periods with you. And in fact, we give you an acknowledgement, and it's contained in the acknowledgement so that you will know to track those times because you don't want to miss them.
Yeah. Okay, so I just see here that we got another question from Facebook from Shazia, so thank you. And it goes back to what we were talking about with social media about should I unfriend my ex during divorce?
Well, I wouldn't say just unfriend. You're probably better to block, but you have to think about what you're doing here, and it relates to what you're posting. We give we give some advice when a client hires us. And one of the things we do is to tell them to block their former spouse from Facebook. But this depends on what you're posting. Because when you're posting on Facebook, for example, if you go on my personal Facebook page and you look at it, there's nothing personal on there. It's really all business. So I have not unfriended my ex, and I don't see any reason to unfriend my ex. Mm-hmm. But the other place you go to is now as kids become friends on Facebook, they may notice if one parent has blocked the other parent or unfriended the other parent and may or may not ask why. Yeah. So you have to think about how it ties into your kids and what you're posting. So if you're self-employed and you're telling your spouse, I'm struggling financially, and you're posting your great and beautiful vacations to all sorts of exotic places, you know you're asking for trouble.
Yes.
But guess what? Even if your ex can't see them, it doesn't mean they're not picking up the friend and calling somebody else to take a look and they're showing it. So as much as you may think you're keeping it from them, you're probably not. So I would say probably a good idea unless you're worried about the fallback from your kids. But in any event, every time you post, you're keeping a digital record and assume that your spouse, your former spouse will see it and that it may end up in court one day. And is what you're posting inconsistent with what you're telling your ex-spouse? You know, this isn't on Facebook, but I always think of the story where this guy goes out and buys himself a new Porsche, and then he picks up his kids on Friday from his former spouse's house. And then by Wednesday the next week, he's served with the motion to change materials by the former spouse wanting more support.
What?
Well, if somebody sees you're moving up in how you're living, they want a piece of it.
Yeah, so, that makes sense. And it's now I think people don't realize that lawyers and stuff are looking at your social media, you know, to see how your life is. And what you said about privacy settings is so true that Facebook tends to act first and say sorry later. So you might think that you're private, but you're not private. And
that's why the best place to assume is that they're going to read everything. Yes. You know, I look at it and say, somebody says they're not working, they're unemployed. So I Google their name. Up comes their LinkedIn profile showing where they're working. I say, thank you. So that's why I say there's a real problem and a disconnect with assuming that what happens on the web doesn't get seen by the other side. It does. You need to assume it because it will happen.
Yes. Okay. So I have another question from Rena on Facebook. How do I prove a common law relationship did not exist?
Well, first of all, in order for it to be a common law relationship, it has to be a relationship resembling marriage for 3 years or a relationship of some permanence that resembles marriage and they have a child. So the other person has to make sure it gets over the 3-year hurdle or they have a child. Now that can be challenging to try and prove the negative. But how do you try and prove a negative? Well, you start with trying to say, what are the obvious things that somebody would do if they said they were together? Has somebody put the other one on their benefits at work or not?
Yeah.
Okay. How did you file your tax returns? Did you say common law or single? Did you travel together on trips? Did you maintain separate residences, which may not be the be all and end all, mind you, because my residence could be up north and my partner's residence could be downtown, and I come to work Monday to Thursday and stay at her place, and then on the weekend we go to my cottage. But you want to say to yourself, look at how we're living. What external evidence do I have to show whether we were living together or not? If I'm living in a condominium, how many parking spots do I have in the condo?
Yeah.
Was there rent paid for a second spot? How often was this car signed in? Because were there logs on it?
That's really interesting.
You think of those things. If I'm living in a house, as an example, did I have cameras outside the house? So maybe I have some recordings of how often this person was over or not over. What's their address on their driver's license? Now, keep in mind, when you get into an address on a driver's license, it's not as uncommon if somebody's old address is their parents' address, that they may just say, I'm leaving it at my parents' address. I mean, I've used my office address as my primary address for mailing for the past 20 years, probably, because I'm not moving from my office. But if I moved out somewhere and I left it as my parents, that may not be telling. But if I'm trying to say, well, I rented out my condo and I moved in with my girlfriend at her house, well, then why am I still getting all my mail at my former house? Why am I getting my driver's license? Why am I still paying the utilities? I mean, look at their bank statements. You can ask for the bank statements. What bills were they paying? Were they paying bills for this house if they had an income?
Yeah.
Were they paying bills on their other home? So there's a lot of questions, and it's really a matter of sit down, think about the facts of your case, and be creative about finding what would be consistent with us having two separate homes.
Yeah.
How do I prove it?
That's a lot of good stuff, actually. Hopefully that helps. Another question we got was about fees. So on Facebook, we got a question about family law fees. Can you explain how contingency fees work? And is it always this way in family law cases?
Well, that's really simple, because in Ontario, there's something called the Solicitors Act. And the Solicitors Act says family law lawyers are not allowed to charge contingency fees.
Oh, okay.
So it's not permitted here in Ontario. And when you think about it, it really makes sense to me, at least. I know some other jurisdictions do it, and I'm not sure how they do it, because if I'm trying to get somebody a claim for division of net family property, and their spouse has a house that has equity of $2 million in it, and in the current real estate market in Toronto, that's not outrageous.
Yeah.
How much work am I really doing to get their half?
Yeah.
Equalization, not much. That legal fee that would be based on a contingency fee would not be pure insanity in my mind. So I'm not sure how you could do that. As much as I'd like to be paid that way, it's not fair to the client.
Yeah.
And I always remember I once had a client, she was getting a multi-million-dollar settlement, and she said, don't I have to pay you a third of it, which would have been 7 figures to me? And I said, no. She goes, what do you mean? I said, you're paying me on the hourly. You know, I told her how much she owed me, and her mouth dropped open because it was a fraction of what she thought she was going to pay.
Really?
In Ontario, you can't take contingency fees. It's not allowed for family law, period, end of story.
Really? That's interesting. So, because I guess some areas of law do contingency. So that's great.
Well, other areas of law are permitted to do it. I mean, the one that comes to mind is personal injury. A lot of cases will be on contingency fee. The same, some are employment law, but in family law, it's just not permitted. So it's not even an option. It's not open for discussion.
Yeah, that's interesting. Okay, so we got another question by Facebook. Lots of Facebook questions. It has to do with property. Can one spouse force another to sell the home? Is it always a good idea to get agreements in writing when discussing division of assets?
Okay, I'm going to start with the second question. I always think of nothing happen if it's not in writing.
Yeah.
So if you're dividing your assets, you should go to lawyers, have it properly drafted, have the proper disclosure, and have it reduced to writing where each of them have witnesses and independent legal advice. That will ensure that the agreement is least likely to be set aside at a subsequent date. Now, the other part of the question was sale of the home. If they are both on title of the home, then the Partition Act applies. And the Partition Act says that either person can apply for the sale of the home, and it can only be resisted if that person who's applying is doing it because it's frivolous and vexatious or impacts a claim for exclusive possession. I can tell you in my experience, the home will just about, if it's jointly owned, will almost always be sold. It's very hard to resist it. The bigger question is when.
Okay. We got another question from Shazia here. It says, I got a cost order that my ex has to pay $3,000 due 1.5 months ago. She does not want to pay. I do not want to go to court. How do I garnish her wages?
Well, you may want to go on our website, familylawhelp.ca. I'm not sure if we have instructions on it regarding garnishments, but there are forms under the family law rules that will allow you to garnish her wages or garnish her bank accounts as well.
Oh, wow.
So that's how you would get paid if you want to go do the garnishment yourself against her. There's also other remedies that you can deal with because, quite frankly, she shouldn't be able to take another step in the proceeding in court until she's paid those costs. And you'd have good reasons to object her taking any steps until she's paid those costs.
Interesting. Okay, and this is another question we got from Twitter. It's the last question we have, was what's the most common reason people avoid talking to a family lawyer?
Well, I think it's a pretty obvious reason. People are scared of what it's going to cost. I mean, the bottom line is people are concerned about legal fees. Lawyers in general don't have the best reputation in the public eye. And some people will come in thinking all we want to do is run up our fees, when in fact, we want to make sure that A, we're getting you a fair and reasonable deal. Do we want to get you the best possible deal? Absolutely. But we also have to balance that with what we're going to charge. Lawyers, unfortunately, we are not inexpensive. We are expensive. And there are ways to try and control your costs, because the more you can communicate with your ex, give the proper disclosure, make a fair deal. And if you instruct us with respect to a fair deal, then it's incumbent on us to properly paper that fair deal. And that will get you the least expensive resolution and get the biggest bang for your buck, but it still needs to be papered properly. And I have clients coming in all the time who say, I don't want to give the disclosure. I don't want to give the disclosure. Can't you just write it up in 2 pages on paper? And the reality is, the family law says you must give financial disclosure. It doesn't say you may. It doesn't say it can be waived. It says it must. So you know as a lawyer that if the agreement is a good deal for your client, that the other side may one day want it reviewed by saying this should be set aside. The easiest way for them to do it is lack of financial disclosure. And in fact, the Court of Appeal has said, not only is that a ground to set aside the agreement, but in making that determination, if you haven't given the disclosure, the Court of Appeal can look at the fairness of the agreement. Because that's the only place fairness becomes relevant. So if you've done an agreement you haven't given, and you've given the financial disclosure, the court could set it aside because it's unconscionable, which in my mind is different than saying it might have been not a fair deal because one side did better than the other. But if you didn't give that disclosure, the threshold is coming down. So clients sometimes look at me and think, Andrew, you want to give this just because you want to make money? No, I want to give the disclosure because I don't want to be dealing with this 3 years from now when your former spouse thinks this is a bad deal and I want it set aside. And believe me, I have clients come back with those bad deals who we didn't do, who I inherit from other lawyers or law firms, I should say. And then we're saying, you didn't get the disclosure. We want this agreement set aside. And imagine how you feel when you in your mind are thinking, I have this final deal. I have my closure. I'm planning my life accordingly. And here's my former spouse again coming after me for more money. And you walk into a lawyer's office who says, well, you didn't give the disclosure. You didn't paper it very well. You may very well see yourself paying more.
So it might seem harder in the beginning, but it's much better in the long run to actually do.
Absolutely. The simple thing I tell people is that that's a form of insurance that you're really buying.
Yeah.
Would you buy a house and not get insurance?
Never.
And a house is your single biggest asset. Whereas the separation agreement that you sign will be in most people's lives, will be the single most important agreement that they sign because it's dealing with half of their assets and a very large income stream for many years to come. Why wouldn't you want the insurance for that too?
Exactly. No, that's It has to do with so many things in your children and your life and everything.
So it escapes me when people want to do that, and people sometimes want to get to that place of closure so fast and move on with their life. They're not stopping and realizing what we're asking for really isn't that challenging, because usually it's the last 3 tax returns and your notice of assessments for those years, and the backup documentation for your assets and liabilities. Most people, if they don't have a pension, and if they do have a pension, it's easy to get it valued in Ontario now. You go to your pension administrator to do it. But most people, their biggest assets are their bank accounts, their investment accounts. Well, you can go online, get me the statement.
Yeah.
And you're gonna have, and if you deal with 1 bank or 2 banks, you get the statements. It'll have your credit card debt, your mortgage debt, and you don't have to go appraise the home if one person is buying out the other, because the 2 of you may have had an agreement. And the courts aren't as strict about needing proof of the value of the mat home if people agree, because I tend to think everybody has a decent idea what their house is worth.
Yeah.
People seem to follow that because that's their single greatest asset. And if anything, they think it's worth more, not less than what it actually is.
Yeah.
So that's at least how I see that flow of it is get the disclosure. Don't not do it. It's fairly simple. It's fairly straightforward. Do it.
Great. So that's all the questions we have for you today.
And we have 3 minutes left. So we're running early today. That's not good.
I know. Well, there was one question I actually had. It popped into my mind. So maybe I can ask you.
What's that?
Talking about the services. We talk a lot about, or we've discussed a lot about unbundled family law services. Can you talk a little bit about that and explain what it is?
Well, historically, people would hire a lawyer to do everything, and that would be the comprehensive version. So that would be everything beginning to start. People are finding that they can't afford a lawyer to do everything from beginning to end. So now what they sometimes do will hire us for a distinct task. So we may end up helping draft a conference brief, helping draft a motion material, or going to court on a specific attendance for the client. We may coach the client and give them advice on how to draft, how to make their presentation to court. So that's something that we find helpful. And in order to try and help people, we created that other website that I mentioned earlier, familylawhelp.ca, to try and give the public guidance and assistance at preparing things on their own. But we're here to be hired and help people on a case-by-case basis if they can't afford us to do everything on a per-step basis. I always say to people, I would recommend the comprehensive service because that's the best. But if you can't afford the comprehensive service, better to have something than nothing. And we can help you and perhaps get you through the process. And I remember I had one client came to me and he had a motion that he wanted to bring to reduce his support against his wife. And we prepared all the motion materials and we coached him how to argue it. And he went to court and he actually beat the other lawyer and got a lot of his costs back on the motion because we drafted them and we told him how to present it. I don't think the other lawyer was expecting that.
No, they wouldn't.
Yeah, and then the same case, he came back about 2 years later when it's going to trial, and he said, Andrew, I want you to help me settle it. So we had a settlement meeting with the other lawyer that I attended. He explained to me where the file was. So I spent a couple hours preparing for the settlement meeting, attended the settlement meeting, and we got the case settled. And that
lawyer wasn't too impressed with that.
Well, it's perfectly fine to do that. But the key there is this gentleman was really smart at picking his times that he wanted our help. And he got a great bang for his buck because we got him through the motion and we got his case settled and we got it at just the right times for him. Not everybody's going to be as good and selective and get as good a result as he did. But that was a great example of how unbundled legal services really can work for somebody if they pick the right time.
That's awesome. That's perfect timing too, because I think we're at 1:30 mark.
All right. So then I want to say thank you to everyone for watching today. I hope you've enjoyed the show. I wanted to remind everyone that the next show will be on Thursday, August 17th at 1 p.m. If someone has a topic they'd like to request, please send us an email to info@feldsteinfamilylaw.com or message us on Facebook, and we'll consider the topic that you're suggesting. Hope everyone's enjoyed the show and have a great afternoon.